Alomo.elicum. Welcome back to our channel, True Courtroom Stories.
Kindly subscribe our channel, like and share with friends, and this is the episode 105 of True Courtroom Stories, researched by Mr. Zahir Ahmadmir.
Welcome back to the deep dive. We are so glad you've joined us for what I think is a really essential exploration. You've given us this incredible stack of source material. We're talking historical treatises, constitutional articles, major court judgments, and they all focus on one of the most powerful concepts in law.
And one of the most misunderstood, I think.
Absolutely. We're talking about judicial review. Okay, let's unpack this. What we're really talking about here is the power of a judge, someone who isn't elected, to look at a law passed by Parliament. You know, the people's representative.
Or an order from the chief executive.
Right. And for that judge to just declare it invalid, to say, no, this is unlawful, it's an incredible amount of power. So for this deep dive, our mission is to really synthesize these examples you found, examples from across millennia and continents. We want to find that universal principle that empowers the judiciary to be the ultimate check. We're going to go from a Qadi in classical Islamic history to the U.S. Supreme Court's early days, and then bring it right up to modern-day Pakistan.
That's the perfect way to frame it, because when you strip everything else away, all these different legal traditions, the core philosophical idea, the foundational ratio, it's actually deceptively simple.
It is, isn't it?
It's just this. Courts exist to say what the law is.
It sounds so mundane, so obvious, like we're just reading a job description. But as you say, that simplicity hides an immense amount of power.
It is the source of the ultimate check. I mean, that one simple statement creates the institutional firewall against runaway government authority. Think about what it means in practice.
Okay.
It means the will of the legislature, even if it represents, say, 99% of the public, or an action by a president or prime minister. It's not the final word.
The law is the final word.
The higher law. The Constitution, or a foundational text, that's the supreme word, and the court is the one independent body tasked with speaking for that supreme law. It completely shifts sovereignty from the temporary government to the permanent constitution.
And that's the moment the check is created.
Yeah.
When the power moves from the lawmaker to the interpreter.
Exactly.
So, our purpose today, for you listening, is to really get how this simple ratio works in three very different, but as we'll see, deeply related legal worlds. We're going to see how this judicial check is a consistent global idea, whether it's centuries old, strategically created, or written explicitly into a modern constitution. So let's start by just grounding ourselves in that functional definition. What is judicial review?
At its core, it's the authority a court has to look at an executive action or a legislative one and to formally decide if it violates a higher foundational law.
Which, in most modern countries, is the Constitution.
Right, the Constitution. And this is where we have to connect it back to you, the person listening, and asking, why should I care? Why is this worth a deep dive?
Yeah, why does it matter?
Because this concept is the ultimate nonviolent structural guarantee for your fundamental rights. It's what ensures stability.
Yeah.
It's what protects a minority from the impulses or even the tyranny of a temporary majority.
So without it?
Without judicial review, the whole idea of rights, your right to free speech, to property, to due process, it could all be taken away with a simple majority vote. Or an executive order.
The Constitution would just become a piece of paper, a suggestion.
A political manifesto, exactly. Not a binding contract. So the written guarantees would be worthless.
The stakes are huge then. But let's dig into that ratio itself. Courts exist to say what the law is. This is where the real tension is, isn't it? When a court looks at a law passed by people, elected by millions, is it really just interpreting? Or is it, engaging in a political act of setting limits?
Well, that tension is inherent in the system. There's no escaping it. When a court strikes down a statute, they are, by definition, frustrating the will of the elected representatives.
And that's when you hear the criticism. Judicial activism. Unelected judges making policy.
All the time. Critics will say the judiciary is an anti-democratic force, that these unaccountable judges are just substituting their own preferences for the will of the people.
But the court's defense is always rooted in that same ratio. They'll say, we're not being anti-democratic.
You're being anti-unconstitutional. Precisely. The entire argument rests on a hierarchy of law.
Explain that.
The Constitution is established by the people through some kind of sovereign founding moment. It is therefore supreme. Ordinary laws, passed by temporary representatives, are subordinate to it. They're lower on the pyramid.
So when there's a conflict?
The court's job isn't to choose between two equally valid laws. Its job is to uphold the superior law. By declaring a legislative act void because it conflicts with the Constitution, the court is just saying, in effect, that thing you passed, that's not actually law.
So it's a declaration of nullity, not a political veto.
Exactly. It's saying this was never a valid law in the first place because it violates the higher permanent law we are all bound by.
That distinction is so critical, isn't it? Saying an act is not law, rather than I disagree with this law. That's what maintains the court's legitimacy.
It does all of the structural work. It positions the judiciary not just as another branch of government, but as the ultimate guardian, the authoritative interpreter of that foundational text. And that idea of constitutional supremacy is the bedrock for every single example we're going to talk about today.
It's like the Constitution is the architect's blueprint for the house of government. The legislature can build the walls and the executive can arrange the furniture, but the court is the one holding the original blueprint, making sure every new addition actually fits the plan.
That is a perfect analogy.
Yeah.
And that mandate, holding the blueprint, transforms the judiciary from just a dispute resolver, settling contract disputes, into a constitutional sentinel. It's the only branch that can officially tell the other two that their actions are legally void.
But let's play devil's advocate for a second, because this is where it gets complicated. The court holds the blueprint, fine. But what if the blueprint is old? What if the lines are faded or, just vague?
Mm-hmm.
When a court has to interpret something as broad as equal protection or due process, isn't it doing more than just saying what the law is? Isn't it, in a way, defining what the law will be for the future?
That is the perpetual tension. That's what drives legal debate across the world. The theoretical ideal is pure objective interpretation. But the practical reality is that when a text is silent or ambiguous or you have to apply it to something completely new like digital privacy.
Things the founders never could have imagined.
Exactly. The act of interpretation inevitably generates new legal principles. But, and this is the key, the legitimacy of it all rests on the assumption that judges are constrained. They're constrained by legal methodology, by history, by precedent.
Whereas the legislature is just constrained by politics, by popular will.
Right. So the court acts as that necessary counter-majoritarian force to stop the whole constitutional structure from collapsing under the weight of political convenience. Every example we have today, from the Quadrant of Marshall to Article 184.3, is really just a different historical attempt to manage that exact tension.
Which is a perfect transition. That structural necessity is exactly what Chief Justice John Marshall was facing in 1803. So let's turn to the case that really codified this for the modern democratic world. When people think judicial review, they almost always start here. Marbury v. Madison.
The blueprint.
The 1803 U.S. Supreme Court case that became the blueprint for constitutional supremacy everywhere. To understand it, you have to understand the scene. This case came out of a frantic, almost desperate political transition. The election of 1800 was brutal.
It was a political earthquake.
John Adams, a Federalist, lost the presidency to Thomas Jefferson, a Democratic Republican. It was a complete shift in power.
And the Federalists, they realized they were about to lose control of everything. The presidency, the legislature. So they made a last-ditch effort to hold on to power by colonizing the third branch, the judiciary.
The famous midnight judges.
Exactly. Before Adams left office, he and the outgoing Federalist Congress rushed through a bunch of new judgeships and other commissions.
They were literally staying up until midnight on Adams' last day in office, signing and sealing these appointments, just trying to pack the courts with their guys who would serve for life.
It was chaos. And one of those commissions for a man named William Marbury to be a justice of the peace. It was signed, it was sealed, but it just wasn't physically delivered before Jefferson took over.
And Jefferson was, understandably, furious about this whole maneuver.
Of course.
Yeah.
So he immediately told his new Secretary of State, James Madison, don't deliver any of the remaining commissions, not one, including Marbury's.
So Marbury decides to sleep. He goes directly to the Supreme Court and asks for a writ of mandamus.
A court order.
Right. An order compelling a government official, Madison in this case, to do his job and deliver the commission.
And here's the crucial part. Marbury's entire case was based on a specific law, Section 13 of the Judiciary Act of 1789. That act, passed by Congress, seemed to give the Supreme Court the authority to issue these kinds of orders directly. It gave them original jurisdiction.
The power to hear the case first.
Right.
Now, this is where we see the genius of Chief Justice John Marshall. He's the head of what was then the weakest, least respected branch of government. And he's facing off against a powerful and popular new president, Thomas Jefferson.
And he's in a no-win situation, a real bind. If Marshall orders Madison to deliver the commission, everyone knew Jefferson would just ignore it.
He basically say, make me.
Exactly. And the court had no army, no way to enforce its order. Its authority would be completely shattered. The institution might never recover.
So Marshall understood he couldn't force a confrontation he was guaranteed to lose.
He couldn't. So he engineered a ruling that was, on the one hand, a political surrender to Jefferson. But on the other, it was an institutional masterstroke that secured the court's ultimate power forever.
It's all in how he structures the ruling, right? Those three famous questions.
The three questions every American law student memorizes. First, did Marbury have a right to the commission? And Marshall says, yes, absolutely. It was signed and sealed. The delivery was just a formality.
Okay, so step one, he establishes that Marbury was legally wronged.
Step two, if he has a right, does the law give him a remedy? And again, Marshall says yes. He asserts that even the executive branch is not above the law.
So he's really setting the executive up here. He's raising expectations, making it seem like Marbury's about to win.
Precisely. And then comes the brilliant third step. The pivot. Is the Supreme Court the proper place to seek that remedy? What about jurisdiction? Marshall turns to the Constitution itself, to Article 3, which defines the Supreme Court's jurisdiction. And Article 3 is very specific. It lists only a few cases where the court has original jurisdiction-like cases involving ambassadors or states. In all other cases, it says the court has appellate jurisdiction. It hears appeals.
And a petition for a writ of mandamus against a federal official that wasn't on the original list in the Constitution.
It was not. So Marshall declares that Section 13 of the Judiciary Act of 1789, the very law Marbury was relying on, was an attempt by Congress to expand the Supreme Court's original jurisdiction.
Which it couldn't do.
It couldn't do because it conflicted with the specific text of the Constitution. Therefore, Marshall says Section 13 of that act is void. It is unconstitutional.
And there it is, the aha moment, the perfect political sacrifice. He rules against his own political ally, Marbury. He surrenders the immediate power by saying, sorry, we can't issue this order because we don't have jurisdiction under the Constitution.
But in that very act,
he secures the immense permanent power, the right of the judiciary to strike down an act of Congress.
He basically told Jefferson, you win this little battle. Madison doesn't have to deliver the piece of paper.
I have just established the rule that I, the Chief Justice, get to decide if any law Congress ever passes is valid.
That's it. It was the first time the U.S. Supreme Court truly said what the law is, asserting that the Constitution is a higher law that the judiciary must protect, even if it means invalidating the work of the legislature. And that single strategic move became the foundation for judicial review across the globe.
It's incredible. He sacrifices a pawn, Marbury's little job, to secure the Queen, the permanent power of judicial review. And that ability to check the legislature is a principle we see reflected everywhere, even in much older legal systems.
That's a vital point.
That last point is crucial, right?
Yeah.
Judicial review isn't some purely modern Western invention. It's not unique to common law. The source material you gave us points to ancient systems of checks and balances where a higher law was enforced by a judge.
That historical continuity is so important. When we look back, the functional principle of a judicial authority checking the executive against a foundational legal text, it exists completely independently of 18th century politics or modern constitutions. It speaks to a universal need to curb arbitrary power.
So let's introduce the specific parallel from the sources. The Qadi overriding a governor's decree.
Right. To really get this, we need to understand the roles in classical Islamic governance. You had the governor, the wali or emir. He represented the temporal, the executive authority.
So administration, taxes, defense, the day-to-day running of the state.
Exactly. He was the political manager. The Qadi, on the other hand, was the judge. And the Qadi's legitimacy didn't come from the governor. It came directly from the sources of the Sharia, the foundational legal text, and the discipline of Islamic jurisprudence, or fiqh.
So the Sharia in this context is functioning as the higher supreme law. It's the Constitution.
Structurally, yes. It was seen as the fundamental, unchanging law. So the governor is operating under the temporary rules of the executive, while the Qadi operates under the permanent rules of the foundational text. And if they conflict,
the Qadi has to uphold the permanent law.
He has to. He's the legal safeguard. So let's imagine a scenario. A new governor comes in, he wants to fill the treasury, so he issues a decree imposing a new arbitrary tax on local merchants. a tax with no basis in established Sharia principles.
That's a clear case of executive overreach. It's functionally the same as a modern legislature passing an unconstitutional tax bill.
It is functionally identical. In that situation, the merchants could appeal to the Qadi, and the Qadi, after consulting the relevant texts and precedents, would rule that the governor's decree was unlawful because it violated the established principles of justice in the Sharia.
So what happens then? The Qadi can't arrest the governor.
No, but he can nullify the legal effect of the action. He would refuse to enforce or recognize the decree in his court. He effectively strips the decree of its legal authority. The Qadi's role was to ensure that the temporal power of the governor stayed within the lines drawn by the permanent established principles of law.
It's a powerful demonstration that the check on the executive is not a new invention.
Not at all. And this example is so important because it shows that the underlying ratio, that courts exist to say what the law is, even when it's against the ruler, it isn't culturally specific to Western constitutionalism. It's a universal governance principle that just emerges wherever you have a fixed, higher legal authority that exists above the current government.
And that universality is really key for you, the listener, to grasp.
Yeah.
Whether that higher law is a divine text interpreted through rigorous scholarship or a secular constitution ratified by the people.
The judiciary's structural role as the umpire remains constant. It's what solidifies their mandate to protect the system's integrity against temporary political wins.
But let me challenge that a bit. In many of these historical states, the Qadi was still appointed by the caliph or the sultan, right? So if the supreme political leader appoints the judge, how can that judge ever be truly independent when he's challenging the leader's own governor?
That's a great question, and it gets to a different kind of balance of power than what Marshall engineered. Yes, the appointment was executive, but the Qadi's authority was derived from his legal knowledge, his expertise in fiqh.
Oh, okay.
His legitimacy depended on the recognition from the public and from the community of scholars, the ulama, that he was interpreting the Sharia correctly. If al-Qadi made a ruling that was politically convenient but legally unsound, he would lose his religious and scholarly legitimacy. His judgments would become, in practice, unenforceable.
So his power was rooted in competence and legitimacy, not just political appointment.
Exactly. That acted as a powerful check on the ruler. And that structural dependency on a body of knowledge and precedent, rather than a popular vote, is what gave the ancient judiciary its independence. It's a fascinating contrast to the secular structure of Marbury, but it fulfills the exact same constitutional function.
So having established these ancient and foundational principles, let's jump forward. Let's look at concrete, codified constitutional mechanisms in contemporary Pakistan.
Right.
Because unlike the U.S. system, where judicial review was kind of inferred and strategically established by Marshall, in Pakistan, the power is explicit, it's robust, it's right there in the constitutional text.
And that explicit codification is a massive institutional advantage. It means there's no debate about whether the courts have this power. The debate just shifts to how they should use it. And for that, we need to focus on two primary articles from your sources, Article 199 and Article 184 of the Constitution.
And here's where it gets really interesting, because these two articles set up the ultimate check in two very different ways. One is for, let's say, routine administrative justice.
That's 199.
And the other is for major systemic constitutional intervention.
That's 184.3.
Let's start with Article 199. This details the jurisdiction of the high courts.
Article 199 is the absolute workhorse of judicial review in Pakistan. It is the main tool that ordinary citizens use every single day to ensure the government is acting fairly and legally. It covers everything from a local town council to a powerful federal agency.
The article gives the high courts the power to issue various orders, what we commonly call writs. Can you break down what these writs actually do? Because they're the mechanism, the tool the court uses to say no to the executive.
Absolutely. This writ jurisdiction is the heart of administrative review. It lets the high court scrutinize and potentially overturn the actions of pretty much any government authority. We can break them down into 5 key types.
Okay.
First, you have mandamus, which just means we command. This forces a public official to do something the law requires them to do.
So, for example, if a government office is refusing to issue a license you've legally qualified for.
A writ of mandamus forces them to do their job. Then there's prohibition. This stops a court or a tribunal from doing something that's outside its legal jurisdiction. It keeps them in their lane.
Makes sense.
Third is certiorari, which means to be informed. This is used to quash, to invalidate a past decision by a lower body that was made without jurisdiction or was fundamentally unfair. This is huge for overturning things like wrongful dismissals of employees.
Okay, that's a check on past actions.
Exactly. Then you have the big one, habeas corpus. You shall have the body. This is the ultimate tool against arbitrary detention. It forces whoever is holding a person, usually the police, to bring that person before the court so the judge can determine if the detention is legal. It's a direct protection of personal liberty.
And the last one.
Quo warranto, which means by what warrant. This is a legal inquiry that asks by what authority a person holds a public office. It's a check against illegal appointments or officials who overstay their legal term.
Wow. I mean, that is an immense scope. It covers everything from challenging an official's right to be in their job to making sure a citizen isn't just locked up and forgotten.
It's continuous systemic oversight. Article 199 turns the high courts into these constant watchdogs over the day-to-day machinery of government. Whenever a decision is illegal or irrational or procedurally unfair, the court steps in with a writ and says, the law doesn't allow this, so this action is void. It's the constant application of that say what the law is ratio.
Now let's move up to the Supreme Court's specialized tool, Article 184.3. This is the one that often generates the most headlines, the most controversy.
It does, and for good reason. It's an incredibly powerful and proactive tool.
So what does it say?
Article 184.3 gives the Supreme Court a very specific kind of original jurisdiction. It says that if the court believes there's a question of public importance that involves the enforcement of fundamental rights, it can step in and make an order.
So it bypasses the whole lower court system, but only for really big issues that affect a core constitutional right.
Precisely. And the key difference here is the unique power of suo motu. It's a Latin term meaning on its own motion.
What does that mean in practice?
It means the Supreme Court doesn't have to wait for someone to file a lawsuit. If the court sees a systemic problem of public importance that violates fundamental rights, say, massive environmental pollution affecting millions of people, it can take notice proactively. It can start the case itself.
So the highest court can essentially look out at the country, see a huge constitutional injustice happening, and say, we cannot wait for a single plaintiff to crawl through the system. We have to intervene now.
That's exactly it. It represents a massive shift in the judicial role, from a reactive body that just decides cases brought to it, to a proactive guardian that can step into governance voids. It might take suo motu notice of contaminated public water, which is a clear violation of the fundamental right to life, even if no single individual has the resources to bring that case.
You can immediately see how this would be controversial. This proactive nature drags the Supreme Court directly into the policy realm. Its decisions become inherently political.
They do, and the implications for the bigger picture are profound. This power allows the Supreme Court to intervene directly and immediately in matters of national public policy. It transforms the court from just an apex appellate body into an institution that actively shapes and defends the constitutional order on the ground.
But the critics would call that judicial overreach, right? Judicial activism.
Absolutely. Critics argue it encourages the court to effectively legislate from the bench or manage administrative affairs, jobs that belong to the other branches. But the proponents, they argue that in systems where the executive and legislature are maybe weak or corrupt or just unwilling to protect fundamental rights, the court is the last resort. And it's a resort mandated by the Constitution itself.
So the big difference we're seeing here is that this power, this political leverage, is explicitly granted by the Constitution. Marshall had to strategically finesse it out of a political crisis.
Right.
The Pakistani framers just decided it was structurally necessary to write it directly into the highest court's job description.
That is the perfect synthesis. Both Article 199 and 184.3 are these explicit, modern articulations of the principle that no government action is beyond judicial scrutiny if it threatens the foundational law. They ensure the judiciary, backed by the text of the Constitution, can always say what the law is and what the law forbids.
We have tracked this single idea, judicial review, across such a vast landscape of time and culture. We went from the Qadi, challenging a governor's decree based on the eternal guidance of Sharia, to Chief Justice Marshall, strategically challenging the U.S. Congress to establish constitutional supremacy, and then all the way to the explicit, robust powers given to the courts of Pakistan under Articles 199 and 184.3.
And the thread is just. It's unbroken. The institutional role of the judiciary is fundamentally the same across all these incredibly diverse systems.
So let's bring this all together. Let's offer synthesis for you, the listener. What we've really seen is the historical and geographical continuity of one indispensable legal idea,
Hmm.
the judicial branch acting as the ultimate umpire.
And that unifying constant is always the ratio. Courts exist to say what the law is. They function as this barrier, this indispensable barrier between temporary political power, the immediate actions of the current government, and permanent constitutional principle.
The established higher law that defines the limits of that power.
Exactly.
Judicial review, at its best, isn't about political preference. It's about maintaining structural integrity. It's the mechanism that makes sure the map, the Constitution, is still governing the journey of daily government. Without the court saying what the law is, the other branches are free to just redraw the map to suit themselves.
And understanding its roots, whether in Fiqh or 19th century American politics, and understanding its modern expression in systems like Pakistan's, is just so key to recognizing the fragile balance of power in any state that's committed to constitutional government.
This whole exploration leads us right to our final provocation.
Yeah.
Something for you to think about long after this deep dive is over. And it goes right back to that tension we identified at the very beginning.
Right.
If the court's job is simply to say what the law is, what happens when that law, the Constitution, is silent or ambiguous? Or it has to be applied to a challenge the framers never ever conceived of?
That ambiguity, that's the crucible of judicial review. Does the need to interpret inherently mean political influence? Or can that ideal of pure, objective legal interpretation actually be maintained?
So when the foundational text is unclear, and the court has to make a ruling that sets a new precedent like defining what public importance means under Article 184 in the middle of a climate crisis.
Is the court still just saying what the law is? Or is it, by necessity, creating law?
And if it is creating law, how do systems with such powerful tools like Pakistan's suo motu jurisdiction, how do they manage that power responsibly? How do you ensure the court remains a constitutional sentinel and not an overreaching policymaker?
The whole debate over judicial restraint versus judicial activism really comes down to that. It's a debate over the scope and the depth of this ultimate check. And it challenges you to think, how do we balance the need for an unyielding guardian of the Constitution with the reality that when interpretation is needed, the judge's decision will shape the very meaning of the law itself?
A profound challenge to consider as you reflect on the ultimate power of the court. Thank you for taking this deep dive with us today.